Some individuals are concerned about the Labor Party's failure to present their own copies of EC8 as used in the presidential election, fearing it could weaken their case. Some speculate that the party deliberately chose not to tender these copies as evidence, leading to questions about why someone would withhold proof. The Independent National Electoral Commission, INEC, defended itself by stating that the Labor Party did not have polling unit agents present in all polling units nationwide. Understanding the probative value of political party agent copies is crucial in election disputes, as presenting INEC Certified True Copies, CTCs, of EC8As leaves no room for technicalities. All parties agreed not to question or object to INEC CTCs or other CTCs in the pre-hearing of the presidential election petition tribunal. It is evident from this context that INEC CTCs hold significant importance in election disputes. Disregarding the fact that the respondents later reneged on their promise not to object to the admission of INEC CTCs as evidence in court, their reasons will be heard during the final address. Recognizing the significance of INEC CTCs, one can comprehend the strategy employed by the Labor Party's legal team. They have tendered INEC hard copies that purportedly demonstrate the manual collection of results, since they were not uploaded on iRev and had to rely on manual collation. Although the EC8A forms relied upon by INEC for manual result collection were tendered in court, they were not complete. Nonetheless, the Labor Party's legal team anticipated the likelihood of INEC failing to comply and provide them with all the required hard copies, even under subpoena. Consequently, they included iRev copies as well, because according to the law, these copies should have been uploaded to iRev immediately after vote counting. Therefore, in the eyes of the law, both sets of copies hold the same weight, as they are merely duplications of the hard copies. At present, it can be reasonably stated that the Labor Party has submitted all the results used by INEC in conducting the election. However, one problem remains: the presence of more than 18,000 blurred polling unit results on iRev. Although INEC may claim to possess hard copies of these missing results, since they purportedly relied on manual collation instead of iRev, the evidence is not before the court. The court can only work with documents that are presented before them. They will solely rely on the documents tendered in court. Consequently, how will this situation affect the Labor Party's petition? Since the documents are evidently incomplete, if the court bases its decision on a limited number of results, it may lead to significant disenfranchisement. In a scenario where 25 million people voted in the presidential election, around 15 million votes are unaccounted for due to blurred results on REV. The Labor Party's legal team considered this possibility by submitting their own results, but not in hard copies, but in a tabulated and calculated form prepared by their expert witness in their control room during the election. This raises concerns about the court's decision, as it suggests a leaning towards result cancellation. The court has 3 sets of evidence before it: INEC hard copies certified by INEC, iRev copies certified by INEC, and tabulated results from the Labor Party, collated in their situation room from result sheets provided by their party agents on election day. These sets represent all the results INEC refused to provide the Labor Party, even under subpoena. The judges can compare the Labor Party's submitted results with the INEC CTCs to verify their accuracy, and for missing results, they can rely on the Labor Party's submissions to compensate for gaps. The court must work with the evidence presented to them, and respondents cannot argue against it. They cannot hold the country or the court hostage, and must act accordingly and determine a winner based on the evidence. Canceling the election is not a viable option due to past experiences and the fact that INEC mishandled the process, refusing to upload the results and announcing predetermined rigged outcomes. Canceling the election would empower election riggers to do more, allowing them to perfect what they couldn't achieve in the previous election. This is not an appropriate way to reward electoral fraud. Additionally, the cost involved in conducting another election must be considered, as taxpayers would bear the burden of financing another election when a winner can be determined based on the previous one. Considering INEC's refusal to submit the hard copies representing the blurred results on iRev, the court should rely on the copies and tabulated results submitted by the Labor Party to make their determination. After all, the copies submitted by INEC are identical to those submitted by the Labour Party. Thus, they should be used as replacements to recalculate the entire results and determine a winner. The defendants may rely on allegations to prove their case, but in this instance, the Labour Party has presented their evidence. They have not refused to submit anything or counter the opposing evidence. Therefore, they cannot hold the country or the court hostage. They cannot prevent the court from doing what is right. The court must act impartially and ensure the determination of a winner. All the results must be examined because the judges have committed to assessing each case based on its merit, not on technicalities. Cancellation should never be an option. This is not just for the sake of the P2B and the Labour Party, but for the sake of Nigeria as a whole. If the court allows it, it would signify the success of premeditated election rigging. And if rewarded, election riggers will become even more audacious, believing they can get away with their actions repeatedly.